Today, July 19th, something happened that will alter the legal landscape of gun rights in this country for generations. And most Americans are still sitting at home with absolutely no idea it occurred. A 5-4 Supreme Court ruling just dropped like a constitutional grenade into the middle of American law, and the fallout is spreading into every single state, every single county, every city block where a law-abiding citizen has ever been told by a government bureaucrat that their fear wasn't real enough, their need wasn't special enough, their life wasn't worth enough to deserve protection. That is what this ruling just obliterated. And if you don't understand what changed today, what the Supreme Court's 5-4 gun permit ruling means for you specifically, you are either going to miss rights that just opened up for you, or you are going to accidentally walk into a felony because you thought the old rules still applied. Neither of those outcomes is acceptable. So right now, in the next few minutes, we are going to cut through every layer of spin, every piece of political noise, and get to the raw truth of what this 5-4 ruling means for ordinary Americans on July 19th and every day that follows. Before we go any further, if you are not subscribed to this channel, do it right now. Hit subscribe and turn on every notification. Gun laws in this country are shifting in real time. What was legal yesterday may not be legal tomorrow, and what was denied to you yesterday may be your constitutional right today. You cannot afford to be uninformed. Subscribe now and make sure you never miss an update that could affect your freedom. Let me take you back to what America looked like before today's ruling shook the foundation. For over a century, more than 100 years, roughly a third of the American population lived under what legal scholars call a may-issue permitting system. May issue. Think about what that phrase actually means. The government may issue you a permit if it decides to. Not shall issue, not must issue, may issue, as in maybe, as in if we feel like it, as in if some official sitting behind a government desk who has never walked through your neighborhood at 2 in the morning, who has never been followed to their car in a parking garage, who has never had someone try to kick in their front door, if that official decides that your fear is legitimate, that your life is dangerous enough, that your circumstances are special enough, then maybe, just maybe, you get to exercise a constitutional right. That was the system. That was what New York's Sullivan Law on the books for over a century forced people to navigate. You had to prove what New York called proper cause, not just self-defense, not just, I want to protect myself and my family, because apparently that's too ordinary, too common, too unremarkable a reason to be granted a constitutional right. You had to prove you were a target, documented threats, a specific danger that set you apart from every other person walking the streets of New York who also, by the way, wanted to protect themselves. California had its good cause standard. New Jersey demanded justifiable need. Maryland required a good and substantial reason. Massachusetts gave local police chiefs the personal authority to decide who is a suitable person, meaning if your town's police chief happened to be hostile to gun ownership on ideological grounds, you were denied before your application hit his desk. Hawaii was arguably the most extreme of all. Hawaii operated a system so restrictive that permits to ordinary civilians were essentially mythological. You had a better chance of winning the lottery than getting a concealed carry permit in Hawaii. And across all of these states, New York, California, New Jersey, Maryland, Massachusetts, Hawaii, over 100 million Americans, nearly 1/3 of this entire country, lived under these systems. For most of them, the answer was no. Your fear isn't compelling enough. Your need isn't special enough. come back when something worse happens to you. That was the system. And as of today, July 19th, a 5-4 Supreme Court ruling has declared it dead. Now let's talk about what the court actually decided, because this 5-4 ruling is more complex and more far-reaching than most reporting will tell you. The core holding is this: the Second Amendment protects an individual's right to carry a handgun outside the home for self-defense. And critically, if you are a law-abiding citizen, the government cannot force you to justify why you want to exercise that right. Read that again. The government cannot make you justify a constitutional right. Think about any other right you have. Can the government tell you that you can only speak freely if your speech is important enough? Can they make you prove that your religion is real enough before you're allowed to practice it? Can they demand you explain why you need Fourth Amendment protection before they'll honor it? Of course not, because that's not how rights work. Rights are not gifts. They are not permissions slips. The government does not hand them out when it feels generous and revoke them when it doesn't. You have them automatically, and the government's job is to regulate how you exercise them, not to demand that you justify wanting to exercise them in the first place. But here's the part of this 5-4 ruling that almost nobody is talking about, and it may actually be the most consequential element of the entire decision. Before today's ruling, courts used what's called intermediate scrutiny to evaluate gun laws. Under that standard, the government just had to show that a restriction was reasonably related to an important government interest. And translation, they said public safety, cited a few statistics, and won. Courts were rubber stamping gun control measures for years under that comfortable low bar. This ruling threw that framework out entirely. What replaced it is called the text, history, and tradition test. Now, when any government, federal, state, or local, wants to defend a restriction on your right to carry, it has to demonstrate that the restriction is consistent with the historical tradition of firearm regulation in the United States. It has to go into the archives. It has to find laws from 1791, when the Second Amendment was ratified, or from 1868, when the 14th Amendment made the Second Amendment binding on states. If the government cannot find a genuine historical analog, a real documented law from the founding era that resembles the modern restriction, then that restriction is unconstitutional, full stop. The Supreme Court is forcing every government in America to justify every gun law it has on the books through the eyes of the founders. And that is a seismic shift in the legal landscape. Now let's get on the ground, because legal frameworks mean nothing until you see what they do to real people in real states. Take New York first, because New York was the state at the center of this case. Before today's ruling, New York City issued concealed carry permits to regular civilians at a rate that was almost comically, insultingly low. Business owners, single mothers working night shifts, workers in high-crime neighborhoods, virtually all denied. After the 5-4 ruling landed, New York couldn't keep the proper cause requirement. It was gone. But New York, being New York, the state legislature responded within weeks by passing the Concealed Carry Improvement Act, a piece of legislation that, reading between the lines, was a direct middle finger to the Supreme Court. They couldn't deny you for subjective reasons anymore, so they did something arguably worse. They designated almost everywhere you might actually go as a sensitive location where carrying is prohibited. Parks, public transit, bars, restaurants, any private business that doesn't explicitly post a sign welcoming firearms, which, if you know New York City, means virtually every coffee shop, bodega, and corner store in all 5 boroughs. They also added mandatory in-person interviews, social media audits going back 3 to 5 years, and broad character reference requirements. Gun rights organizations immediately recognized the scheme for what it was, may issue through the back door, and filed lawsuits. Some of those new restrictions have already been blocked by federal judges. The fight is ongoing, but make no mistake, the core constitutional right is now established in New York. Even as the state tries every legal trick it can find to make that right practically useless, California's story runs parallel. Pre-ruling, in most urban counties, a concealed carry permit for an ordinary person was essentially a fantasy. The good cause standard functioned less like a legal requirement and more like an administrative veto that officials exercised freely. Post-ruling California dropped good cause. But then, exactly like New York, California responded by dramatically expanding its list of prohibited locations and doubling down on character review requirements. Hospitals, public transit, parks, stadiums, bars. The state tried to turn the map of California into a no-carry zone everywhere that actually matters. Courts have been reviewing those expanded restrictions, and some have been struck down. But the patchwork is genuinely treacherous right now. And if you're a gun owner in California who thinks the ruling means you can carry freely, you are wrong, and that misunderstanding could cost you your freedom. New Jersey is perhaps the most dramatic turnaround story under the old justifiable need standard. The entire state of New Jersey, population nearly 9 million people, was issuing only a few hundred permits per year. A few hundred. After the ruling, justifiable need was gone. Applications surged, and the state went from processing hundreds of permits annually to issuing thousands practically overnight. That's not a bureaucratic adjustment. That's a constitutional revolution in slow motion becoming real. Maryland, Massachusetts, both moved in the same direction, both fighting rearguard legal battles to preserve as much discretionary authority as they can. And Hawaii, which tried to argue that its geographic isolation as an island chain somehow exempted it from the Second Amendment. The courts rejected that argument flatly. The ocean doesn't suspend the Constitution. If you're still watching and you haven't subscribed yet, stop what you're doing right now and hit that button, and then come back. Because what I'm about to tell you is the part that separates the people who understand their rights from the people who accidentally lose them. Let me make this concrete with real human scenarios. Because abstract legal analysis doesn't capture what this ruling actually means for the people it most directly affects. Picture a woman. She works nights at a hospital in a rough section of Los Angeles. She finishes her shift at 2 a.m. and walks to her car alone in a parking structure where she's been followed twice in the past year. She called the police both times. Nothing came of it. She wants to carry a firearm to protect herself on that walk. Under the old California system, she applies for a permit. She describes her situation, the incidents, the fear, the documented pattern. The sheriff's office reviews the application and tells her 2 incidents in a parking lot don't constitute good cause. Lots of people feel unsafe at night. Denied. Under today's 5-4 ruling, she applies again. She's a law-abiding adult. She completes the required safety training. She passes the background check. The county has to issue her permit. Her reason is self-defense, the exact reason the Second Amendment was written into the Constitution. No official gets to override that because they've decided her fear isn't sufficiently dramatic. She gets the permit. Now, picture a man who owns a small convenience store in Newark, New Jersey. He's been robbed twice in 3 years. He has police reports. His employees have been threatened at gunpoint. He wants to carry when he closes up at night and walks to his car alone. Under the old New Jersey system, even with documented violent crime at his own business, a bureaucrat still had to decide his need was justifiable enough. And maybe they decided it wasn't specific enough. Maybe they told him to hire a security guard. Denied under this ruling. Justifiable need no longer exists. He meets the requirements, he gets the permit. The state does not get to determine that a man with documented armed robberies at his place of business doesn't have sufficient grounds to protect himself. And in Hawaii, consider a parent, 3 kids, no criminal record, no documented threats, no history of violence or instability. He wants to carry a firearm because he believes in being prepared, because he believes reasonably that the Constitution gives him the right to protect his children. Under the old Hawaii system, he was denied before he finished filling out the application. Under today's ruling, he completes his training, passes his background check, meets the legal requirements, and Hawaii has to issue his permit. And the Pacific Ocean does not create a constitutional exception. These aren't hypothetical people invented for dramatic effect. After this ruling, permit applications surged in every former May issue state. States that had issued a few hundred permits per year began issuing thousands. The demand had always been there. The rights had always been there. The government had just been refusing to honor them. Now, and this is critical, let me address 3 myths that are spreading fast and will get law-abiding gun owners arrested if they act on them. Myth 1. This ruling means you can carry without a permit. Absolutely not. The court ruled that May issue systems are unconstitutional. It did not rule that states are prohibited from requiring permits at all. So if your state requires a permit and you still need one, don't start carrying without going through the proper process just because you read something online about this ruling. Know your state's requirements. Follow the process. Get the permit. Myth 2. All gun-free zones are now unconstitutional. Wrong. The ruling explicitly acknowledged that states can designate sensitive places where carrying is prohibited, and it cited schools and government buildings as traditional examples. States have responded to this ruling by dramatically expanding their sensitive place, and some of those expansions are being challenged in court, but many are still in effect. If your state says you cannot carry somewhere, you cannot carry there, regardless of what you think the ruling implies. Myth 3. Background checks and training requirements are gone. Also wrong. The ruling makes it crystal clear that states can still require background checks, fingerprinting, and safety training as conditions of issuance. What they cannot do is inject subjective discretion into the process. They can vet you. They just can't veto you arbitrarily. To understand where you actually stand right now, think of America as 3 distinct zones. Zone 1 is what you might call the freedom states, places like Texas, Florida, and Tennessee. Over 25 states where permitless carry for law-abiding citizens is already the law. For residents there, today's ruling didn't change day-to-day reality much, but it did something critically important. It locked in a constitutional shield that prevents future legislatures from rolling back those rights. What you have is now protected at the constitutional level. Zone 2 is the compliant states. Ohio, Pennsylvania, Virginia, and others that have operated under shall-issue systems for years. These states already had objective standards. This ruling simply reinforces their model as the national constitutional baseline. Zone 3 is the battleground. New York, California, New Jersey, Maryland, Massachusetts, Hawaii. These states are in a state of active legal flux right now. Laws are changing week to week. A federal judge strikes down a sensitive location restriction on Monday. An appellate court puts that ruling on hold by Thursday. If you live in one of these states, casual is not an option. You have to check your local laws regularly and with BT seriousness. Join a state-level gun rights organization because they are the ones filing the lawsuits and they will alert you the moment something changes. Do not rely on news coverage. It's too slow and too often wrong on the details. Step back from the immediate legal fallout for a moment and look at the arc of where we are. This ruling did not happen in a vacuum. It is the third movement in a deliberate legal progression that has been building for nearly 2 decades. In 2008, the Supreme Court issued District of Columbia v. Heller, establishing that the Second Amendment protects an individual right to keep a firearm in the home for self-defense, not just a collective right tied to organized militias. In 2010, McDonald v. City of Chicago applied that individual right to state and local governments, not just the federal government. That mattered enormously because almost all gun laws in this country are written at the state and local level. And now today's 5-4 ruling extends that right into public spaces and installs the text, history, dust, and tradition test as the new standard by which every single gun law in America must be evaluated. Each decision builds on the last. The right was born in the home, protected from state interference, and now lives in public. And the direction of this progression is not ambiguous, but here is what I want you to sit with, because this is the part that doesn't get covered enough. Who did the old May issue system hurt most? It wasn't the powerful. It wasn't the politically connected. People with the right last name, the right network, the right relationship with the right official, they got their permits. And the system worked perfectly well for them. The people crushed by May issue were the people who needed protection most and had the least institutional access. Single women living in cities where permits were essentially impossible to obtain. Working class people in high crime neighborhoods who couldn't afford private security, who couldn't afford to live somewhere safer, who couldn't afford lobbyists or attorneys, but who could have afforded a firearm and a safety course. Night shift workers, small business owners, immigrants trying to protect their families and their livelihoods in neighborhoods the powerful never visit. The system told them consistently that their fear wasn't real enough and their lives weren't important enough. And today's 5-4 ruling said that has to stop. The Second Amendment does not have an income bracket. It does not evaporate in urban neighborhoods because city officials are philosophically uncomfortable with it. It applies to every American everywhere equally. That doesn't mean the fight is over. It means the terrain of the fight has changed. The states that lost the legal argument over May issue are now doing everything in their power to make the right piece functionally useless through sensitive place designations, through character review requirements that function as ideological screening, through bureaucratic delays and application hurdles designed to make people give up. Some of those retaliatory measures will be struck down in court. Some will survive. The house the court built on July 19th is legally sound, but the walls are still going up. And there are powerful interests who will keep hiring architects to find new ways around the foundation. That is why your engagement, your attention, your voice, your willingness to stay informed matters. The Supreme Court can establish a right. It cannot protect it from being buried in paperwork. Here's what you need to do practically right now. First, know which zone you live in and treat that knowledge as a living, breathing thing that needs to be updated regularly, not something you check once and file away. Second, if you live in a battleground state, join a gun rights organization operating at the state level, not for politics, for information. These are the people who will know before anyone else when a judge blocks a restriction or when a new requirement gets signed into law. Third, if you haven't already gone through the permit process in a state that requires one, do it now, don't wait. The backlog of applications in former May-issued states has grown dramatically. Since this ruling and processing times have lengthened, get in line. Fourth, understand the myths we just dismantled and share them with every gun owner you know, because a gun owner operating on misinformation is a gun owner who is one bad decision away from a felony charge. Today, July 19th, is a date that will be cited in constitutional law textbooks. A 5-4 Supreme Court ruling just moved a legal mountain that has been sitting on top of the rights of 100 million Americans for over a century. That is not a small thing. That is not a partisan talking point. That is a seismic shift in the relationship between the American government and the American people on one of the most fundamental questions any society faces: who gets to protect themselves and who gets to decide? The answer, as of July 19th, is clear. You do. Not a bureaucrat, not a police chief with a personal ideology, not a licensing official who doesn't like your social media posts. You and the Constitution of the United States agrees. Stay locked in. This story is not finished. It is just entering its most consequential chapter. And if you want to understand every development as it happens, every court ruling, every new state law, every restriction challenged and overturned, subscribe right now, hit that notification bell, and leave a comment below telling me which state you're in and what you want to know about your rights. Because your rights are only as powerful as your understanding of them. And right now, they just got a whole lot more powerful.